Okay, well, I do think I am live finally. So thank you very much for joining me, everyone. Welcome. My name, you know it, Lior Samfiru. I'm the employment lawyer. So what does that mean? Well, I'm one of the founding partners of Samfiru Tumarkin LLP. We are the largest employee side firm in Canada. We operate in Ontario, in BC, and in Alberta. And well, why am I here? Hopefully you know, but in case this is your first time, I am here to answer your questions live about your workplace rights, to help you try to understand your rights, to understand your situation, to understand if what you're going through is legal or not, and give you some advice, tell you what to do. We all have a job. We spend more time at work than we do anything else. Spend more time at work than we do with our families, more time at work than we do, hobbies. So it's important that we understand our rights in the thing that we do the most. So that's why employment law is so important. That's why you have to understand what to do. If you lost your job, if you're being threatened with losing your job, if you were written up, if your job has changed, if your compensation was reduced, if you're being mistreated or bullied, whatever the issue, whatever the problem that you're facing, number one, there are solutions. There's answers. It's something that I've seen, that I've dealt with, and you have an opportunity right now to ask those questions live. If you're watching me right now, watching is good. You learn a lot, but it's even better if you ask the question that's on your mind. Ask it right now. Now, before we get started with today's session, let me give you another way to contact me. If you want to reach me and my team off social media, you want to connect privately, to have a private email exchange or private phone conversation, very easy to do. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. When you go to employmentlawyer.ca, you'll have the contact information, my phone number, my email address. It's all there. In addition to that, you can learn a lot about your workplace rights on employmentlawyer.ca. So take advantage. It's there for you. It's there for your benefit. So if you're struggling with something, a good place to start is employmentlawyer.ca. But that's after. Right now, I'm here, Lior Samfiru, live for you, answering your questions. This is a live session here on Facebook, on YouTube, wherever you're streaming. So by all means, take advantage and ask questions. Now, as we're waiting for your questions, I wanted to kind of clear some of my inbox. I wanted to read some of the questions that I've received by email this week. And, I'm not mentioning names or anything like that, and give you the answers, because some of the questions that have been asked may be questions that you're facing yourself or issues that you're struggling with. So hopefully by answering those, I'll be able to help you as well. So our first question that I'm going to read, it came through me by email, is this. I've been on a layoff for 4 months. The company is still operating. I'm told that they don't know when I'll be called back to work. How long do I have to wait? This is a very common situation. You're put on a layoff, you're off work, you're waiting. How long do you wait? How long can they keep you off? Well, here's the thing. They don't actually have a right to put you on a layoff to begin with. So when you're put on a layoff, in most cases, you can treat that layoff as a termination. We call that constructive dismissal. So when you're asking me how long can they keep me on the layoff, the answer is they don't actually have a right to put you on a layoff to begin with. So it's not a question of how long, it's a question of, do they even have the right? Because they don't even have the right, it's up to the employee to decide, how long are you going to accept this? When are you going to have enough? When are you going to say, I'm not accepting this anymore? So in a temporary layoff situation, you have two options. Option number one is you can sit at home and wait. How long? I have no idea, until the company decides to do something. That's option one. Option number two is you can decide, the employee, when you've had enough. You can decide to treat the situation as a termination and get your severance. So it's not how long the company has, it's how long you want to give it. If you've been put on a temporary layoff, if you've had enough, if you want to just get your severance and move on, call me or email me. You can get my contact information at employmentlawyer.ca, and I'll help make that happen. Okay? Hopefully that answers that question. I know a lot of people may be surprised by that. There have been so many temporary layoffs over the past couple of years, and in most cases, despite the pandemic, they're not legal. All right. So I'm going to start answering some questions here. You have time, by the way. Ask your question. I'm Lior Samfiru, the employment lawyer. You're watching me right now answering questions about employment law, so ask yours. Okay. Kennedy Hughes has the first question. Can you help individuals in North Michigan, or can you make a referral? No. So we can only help individuals in Ontario, BC, and Alberta and Canada. That's it. I don't have a referral in the US. I don't deal with US law. So unfortunately, I'm not going to be able to help you in Michigan or can provide a referral. Strictly Canada, specifically Ontario, BC, and Alberta. Question from Tina on Facebook. After working for a company for over 6 months, when I was handed a contract outlining a potential promotion, there's, however, also something about minimum entitlements. Should I sign this anyway? Very common situation. Company comes to you and say, hey, good news. We're going to give you a promotion, a pay raise, whatever it is. By the way, we want you to sign this new employment agreement. Wait a second. There is no reason for you to need to sign a new agreement just because you're being promoted or you're being given a raise. The only reason a company would want you to sign a new employment agreement is because they understand that that agreement is better for the company. So you mentioned minimum entitlements. What that means is that in that agreement that the company wants you to sign, there's language that allows them to let you go at any time with just minimum severance. Something like that can cost you tens of thousands of dollars. It could be the difference down the road between getting 2 years worth of severance and getting 2 months worth of severance. Okay, it could be almost 2 years difference right there. So bottom line, Tina, and for anyone, if your employer wants you to sign a new employment agreement out of the blue, they come to you, you're already working, they just want you to sign a new agreement, be very concerned. It's not good news. It's not a small deal. It's quite a big deal, in fact. So you can't be punished for saying no. And the best advice I'm going to be able to give you today, before you say yes or no or do anything, contact me. Send me a copy. Let me see it. Let me read it. And I'll tell you if it's okay, if it's not, and what to do about it. But to just go ahead and sign it, you could be giving up on many rights that you have that would cost you a lot of money and cause you a lot of problems down the road. So be very careful with that. Thank you for that question, Tina. So you see how easy it is? You type in your question, you hit enter, I see it, I read it, I answer it, and you walk away with the knowledge. So do as Tina has done, do as others have done, and ask your question right now of me live. But in between that, let me continue answering some email questions that I've gotten this week. Next question is, my boss announced that the company that I work for is likely to shut down in the next year. Can they avoid paying me severance if the company shuts down? Again, a very good question and a very common one. So shutting down the company does not mean that the company doesn't pay severance. They still have to pay severance even if they shut down, even if they stopped operating. The fact that they're shutting down does not relieve them of that legal obligation. And even if they were to say, oh, we don't have any money coming in, well, they have other assets. Maybe they own property, they own equipment. They may have accounts receivables coming in. So they still have to comply with their legal obligations. So shutting it down or stopping to operate, closing down the doors does not mean you don't get severance. Now, that is very different than bankruptcy. Shutting down the company and going bankrupt are very, very different things. If the company is formally under bankruptcy protection, that's bad news for the employees. That means you're not going to get severance, or you get a small fraction of your severance, and there's not much that you can do about it. But if it's not in formal bankruptcy proceeding, they've just shut down, easy, you can deal with it, you can get your full severance. But here's something I want you to remember. Don't wait. So if you know the company is shutting down, don't wait until after the shutdown. Let's deal with this now. Okay, before people disappear and it gets more complicated. If you know they're shutting down, let's deal with it now. I would not wait on that. And again, to connect with me, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca to connect with me and my team, get my phone number, get my email address. It's all there. All right. But again, that's for later. Right now, live, I'm here, you're here, answering your questions. Next question comes to us from Mandy on YouTube. I've had to be off sick for almost 2 weeks, and I've provided a doctor's note. My boss says I've been away too many days. I'm on the verge of being fired. What should I do here? That's ridiculous. That's illegal. There's no limit on how long you can be off work. Maybe it's a week you need to be off. Maybe it's a month you need to be off. Maybe it's a year or longer that you need to be off. The only one that can decide that is your doctor. So if your doctor says you need to be off for medical reasons, your boss cannot do anything. He cannot fire you because of it. That's illegal. That could be a human rights violation, wrongful dismissal. So the company doesn't decide how many days you're going to be off. Okay, your doctor decides. So what do you do in this situation, Mandy? Well, all you do is what you've done. Tell them, I'm under doctor's care. I will come back to work as soon as my doctor clears me to return. If they do anything to you, they let you go, they suspend you, they change your job, they reduce your pay, anything, you call me. All right, I'll deal with it. You see how fast they take it back once they hear from me. Your head will spin. They'll do it so fast. It's illegal. Doctor's note. If you didn't have a doctor's note, that would be different. But if you have a doctor's note, that is all you need. And that's all you need in order to be off work. And don't stress out over that. If they do anything, I'll deal with it for you. All right. Thank you for that, Mandy. You see, again, how easy it is to ask these questions, just like Mandy did and Tina and the rest. You type it in, you hit enter, I see it, and give you that answer. Before we continue, let me give you another tool. Let me direct you to another tool that you absolutely have to know about. Every employee has the right to know what's their severance worth. Is it worth 6 months pay, 12 months pay, 18 months pay, whatever that is. So how do you do that? Well, you can always call me and I'll tell you, but there's an even simpler way. All you do is you go to pocketemploymentlawyer.ca. You see that address on the screen, pocketemploymentlawyer.ca. And when you go there, you'll see our severance calculator tool. You click on severance calculator and you use it. It's that simple. You answer a few questions and it's going to tell you if you're owed 6 months, 8 months, 24 months, or anything in between. It's completely free. It's completely anonymous. You don't have to put in your name or the company's name. You don't have to put in your address, none of that. It's just there for your benefit. You can also contact me if you want directly from there, if that's what you want. So take advantage of that. It's the easiest way to find out how much you're owed. By the way, spoiler alert, it's not a week's pay per year of service. It's not 2 weeks per year of service. It could be a lot more than that. And I'm talking maybe 10 times, 20 times even more than that. So if you think you know how much you're owed, put that number in your head and then go to pocketemploymentlawyer.ca. Use the calculator. I can almost guarantee that you'll be shocked when you find out what the real amount is, how much you're actually owed. All right. My name is Lior Samfiru. Of course, I'm the employment lawyer, and I'm here answering your questions live. I'm going to continue doing that right now, but ask your question too. Evan has the next question. If your company is relocating and you choose not to move with them, is this considered a resignation? Well, it depends where they're relocating and how this impacts you. So a company doesn't have a right to make significant changes to terms of employment. So if they move across the street, that's not significant. What's considered significant? Well, significant is if it impacts your commute to work by more than an hour. If it's about more than an hour, it's going to be significant. And if they do that and you choose not to go with the company, you choose to leave, the law does not look at that as a resignation. The law looks at that as a constructive dismissal. So by moving to the point that now it's impacting you by more than an hour, well, that's as if they let you go. Now they have to pay you severance. So it's not about how many kilometers or the distance that the company is moving. It's how it impacts you. The distance they're moving could be very small, it could be very short. But if it impacts you to the point that you're spending more than an hour to get to work and to get home, then that's potentially a constructive dismissal. If you're in that situation, let's talk about it. Before you do anything, before you tell them yes or no or you leave, that's always good advice. Let's talk about it so we make sure you do that right. And to connect with me, of course, employmentlawyer.ca. Again, employmentlawyer.ca. All right, continuing to answer questions. Robert has the next question. He's on YouTube. I was terminated after workers' comp. What do I do? Well, you call me. That's exactly what you do so that we can understand why they let you go, if it's legal or not, so we can assess what you're owed, make sure that you get what you're owed. That's what you do. I'm the guy you call if you lose your job. I'm the guy you call to make sure that you got everything owed to you when you lose your job, and to make sure that that termination is legal. If you were let go after workers' comp, that could be potentially a human rights violation. That could be a violation of the workers' comp legislation. If you didn't get proper severance, that could be a wrongful dismissal. So there's a number of things here, Robert. So you need to connect with me. And Robert, to connect with me and anyone else, employmentlawyer.ca. You see that on the screen right there. Employmentlawyer.ca. You'll see my phone number there, Robert, my email address. It's all there waiting to connect with you, okay? So, there's also, you can scan if you want. Either way, employmentlawyer.ca to connect with me. All right, next question from AJ on YouTube. How does contingency fees work? If a client gets 15 months severance, does that mean the client gets 10 months and the lawyer gets 5 months equivalent plus other costs, assuming the contingency is a third? So what we do is we take a percentage of the improvement. So if you've been offered 2 months severance when you were let go, and we improve that to 10 months, so we've improved it by 8 months, right? Instead of 10, it's now, instead of 2, it's now 10. We take a percentage of that improvement, okay, of that 8 months. Now, regardless of that, one of the things we also do is we negotiate compensation for legal fees on top of that. So whatever the fees are going to be, we expect and we negotiate that the company pays back at least some of that. Maybe not all of it, but at least some of that. Now, the percentage, depending on the case, could be anywhere between 25% and 33%, okay? So those are the percentages that we use depending on the case and the situation. The nice thing about a contingency, fee arrangement is that we take the risk, we put our money where our mouth is. You don't have to worry about funding this, and you don't pay anything until we're successful. And we don't take anything from what you already offered. We only take a percentage of anything extra that we were able to get for you. AJ, hopefully that explains it. Let me know if it doesn't. Happy to elaborate. But right now, we still have some time. Don't wait till the last minute once the session is about to wrap up, because I may not be able to get to your question at that point. Ask it right now. You still have time. You still have time for me to read it and give you a thoughtful answer. So take advantage. All right. Next question right now on Facebook from Tamir. Can your employer decide to ban unpaid sick days? No. This is pretty much the same question as I answered before, because the only one that can decide if you're going to be off work is your doctor. So if your doctor says you need to be off, then what's the employer going to say? Sorry, you're not going to be off? You're not really injured? Of course not. So your employer can decide whether to have paid sick days. In most cases, there's no legal requirement that they have paid sick days. But in terms of unpaid, that's up to your doctor. It's not up to your employer. Your employer has no say in that. So you may need to be off for the next 6 months, 10 months, 2 years. Hopefully not. But if you do, you can be. And there's benefits that may be available to you. You may have a disability plan through work, short-term or long-term disability you can apply for. There's also government benefits, EI sickness benefits you can apply for. But no, it's not up to your employer to do anything with unpaid sick leave. That's strictly up to your doctor, no one else. Hopefully that makes sense. Again, ask follow-up questions. You see how easy it is to get your questions answered. Again, my name is Lior Samfiru. I'm the employment lawyer answering questions. And as I'm waiting for your next question, I'm answering a few email questions as well that came into me. So first question is this, or next question is this. I've been working from home for the last 6 months. My boss just told me that I have to start coming into the office 2 to 3 times a week. Can they do that? So if pre-COVID, you were working from the office, and during COVID, or at some point during COVID, you started working remotely, your employer can tell you to go back to the way things were, all right? So they can tell you, I know you've been working from home for the last while, but now we want you to come back and work in the office. So they can do that. Now, there's 2 exceptions to that. The first exception is a situation where you were hired during COVID to work remotely. So if you've been hired during COVID and you've always worked remotely and no one ever told you that you're going to work in the office, your employer can't now say, well, now we want you to come in. They can't do that. That could be a constructive dismissal. Can't do that. The other situation where your employer can't do that is if the company when you started working remotely, the company told you it's going to be permanent and you relied on that, and now they've changed their mind. They can't change their mind like that. But if they never said it was permanent, it was always going to be just temporary, then yes, they can make you go back to work. Hopefully that makes sense. If you have a question, if you're not sure, let me know. Happy to chat and happy to help as well. Let's see. Next question on YouTube from Tsoika. Have you heard of the Corona Investigative Committee? No, I have not. Next question comes from Faisal. I just handed in my 2 weeks notice, but now I'm being informed my contract stipulated at least a month of notice if I quit. I don't remember this at all. Is this legal? So yes, it is legal if in fact your employment agreement says you have to give us 4 weeks or 6 weeks or 10 weeks notice. Strictly speaking, if that's what you've agreed to, then you have to comply with it. But obviously you'd want to see the agreement. I don't know what it says. Obviously I haven't seen it. That said, all that said, is a practical matter. Your employer can't do much if you don't give them enough notice of resignation. Your employer can't do much about it unless, because of your lack of notice, they suffer financial losses. So if you give them 2 weeks instead of 4 weeks, and because of you didn't give them those extra 2 weeks, they suffered financial losses, they may be able to go after you for those losses. That is extremely rare and extremely difficult to do. So keep that in mind. But when it comes to resignation, if you sign something that requires you to give 2, 3, 10 weeks, then that's a contract and you should give that amount of notice. Okay, Tsoika, I'm not sure what you're talking about there, but that's fine. Next question from AJ. I think AJ has a follow-up. Assuming that there is no government mandate when terminated, to date, what is the success rate of getting severance pay if terminated due to non-compliance with vax policy? Well, I can tell you that we are resolving these cases and settling these cases and getting compensation for these cases every single day. Okay, so every single day, we're resolving more of these cases. So the success rate has been extremely high. And I stand behind what I've said before, that unless there's a government mandate, an employer that lets an employee go because that employee is not vaccinated, that employer has to pay them severance. Okay, their full severance, as much as 2 years' pay. So I stand behind that absolutely. And like I said, we're resolving these cases every day. So AJ, if that's you or someone that you know, contact us. Okay, let's talk about that. Let's assess your specific situation, assess how much you're owed, assess the best way to get it resolved. So you can connect with me. Happy to help you or someone that you know. Again, to connect with me, you see the address below, employmentlawyer.ca, employmentlawyer.ca. There's also this QR code right over there. You can scan that as well. I'll take you to employmentlawyer.ca. All right, next question is from Archie. I've been working as a contractor doing grounds maintenance for 10 years. I was just told that they will be taking bids on my job next year, but I'm welcome to submit a bid. Should I get severance? Absolutely. So if you're doing the same job for 10 years, you probably are not an employee. You're probably not a contractor. You're either an employee or at best something we call a dependent contractor. That means that if they let you go, you're going to be owed severance. So if and when you lose your job, yes, severance is on the table for you, and call me at that point. We'll talk about it. Obviously, you can decide if you want to find a way to continue working with them. But if the effect is that you lose your job, let me know. Happy to help you. And this is actually a very important topic because it comes up very often that someone is misclassified. You work for a company for a while and they're saying, no, you're a contractor. So because you're a contractor, if we let you go, we don't have to pay you severance. But the thing is, if you've been misclassified and you're not really a contractor, they're calling you a contractor, but you're not really. You have a regular job, you've been doing it for a while, etc. The law is going to consider you to be an employee. And as an employee, that means you get severance if the company lets you go, if you no longer have a job. Very common. Now, I mentioned before pocketemploymentlawyer.ca. So in addition to our severance calculator, there's a tool there that allows you to find out if you're an employee or an independent contractor. So when you go to pocketemploymentlawyer.ca, use our contractor employee tool. You answer a few questions and it's going to tell you if you're actually an employee or a contractor. So if you've always wondered, I'm not sure if I'm really a contractor, I think maybe they got it wrong. No need to wonder anymore. You can just go to pocketemploymentlawyer.ca, find out. You can, of course, always call me as well, but very easy to do that. Again, free, anonymous, easy to use, pocketemploymentlawyer.ca. Thanks for that, Archie. Hopefully that helps. Ask your questions. You got the last 5 minutes or so, so we have some time to answer questions, to ask questions. Don't be bashful. Don't turn off your computer today without getting answers to your questions. But as I'm waiting for more questions, I've been answering some emails that I've been receiving. So let's answer some more emails. My company just offered me a promotion, which I do not want to accept. I would like to know if they can fire me for rejecting the promotion. Well, the answer generally is a company can let you go at any time and pretty much for any reason, as long as they pay you severance. So could they let you go because you didn't accept a promotion? Yes, it's kind of a crappy thing to do, right? But legally speaking, they can let you go, but they have to pay you severance. What they can't do is say, well, you didn't accept a promotion, so you've resigned. Absolutely not. Nonsense. No. But if they want to let you go because you didn't accept a promotion, as long as they pay you that full severance, they can do that. Okay? But that full severance, it's not a week's pay per year of service or 2 weeks pay per year of service. That severance can be as much as 24 months pay, 24 months. So you can be let go in most cases, but severance has to be paid. And if you're not get paid, if you don't get paid your proper severance or you're not offered your proper severance, that's what we call a wrongful dismissal. Archie says that I'm a legal eagle. Not sure what that means, but I like it. So thank you very much for that. Better than being like a legal worm or a legal bug. So I appreciate that. Thank you. All right. Next question. Let's see. No name on this one. It's from Anonymous. But after working part-time as a private teacher for almost a decade, we are being informed of layoffs. As I'm a part-time employee, I was told I get less severance. Is this true? Absolutely not. Not at all. Not even close. You get the same amount of severance as anyone else. And your severance is calculated based on your income. So no, part-time employees, seasonal employees, senior employees, junior employees, if you lose your job, you are owed severance. Okay? Don't worry too much about layoff versus fired. So bottom line is about losing your job. If you lose your job, you're owed severance, even if you've done even if you haven't been there long, unless of course you did something terrible. If you did something horrible, something terrible, something that makes it impossible to continue employing you, then you won't get severance. You stole, you committed fraud, you won't get severance then. But otherwise, if you lose your job, even if you did something wrong, yes, you do get severance. All right. Let's see if we get one more question in here. This one is on YouTube from J Muafo. I don't know. I'm probably butchering it. I'm sorry. How long does it take to grievance review board to make a decision in a union? It's up to them. It could be 24 hours. It could be a year, or it could be 2 years. It depends on the case and who's sitting on the board. One important thing to remind everyone that anything you hear me talk about on these segments, or if you hear me on radio or TV, it only applies to non-union employees. It does not apply to union employees. If you're a union employee, the only one that can help you is the union. You cannot hire a lawyer. You cannot hire me or another lawyer. It has to be the union. And I know some people are not happy about that, but that's the way our laws work here for the most part. And also, the laws are different for unionized employees because your rights are contained in the collective agreement. The law kind of stays away from it. So nothing that you hear me talk applies to unionized, only to non-union. I think this is the time that we had for today. So thank you very much for joining me. As always, I really enjoy doing this. I appreciate the questions and the opportunity to help and answer. I'll be back next week. I always am, but don't wait until then. As I said, if you have a question, if you need me to get to work and help you, you can do that now. Just go to employmentlawyer.ca, call me, email me. It's all there. We have a whole team in Ontario and BC and Alberta that helps employees every day, 7 days a week. So employmentlawyer.ca is the place to go. Thank you again. I'm Lior Samfiru from Samfiru Tumarkin LLP. I'll be back soon. Thank you.